Why don't you go see your boyfriend?
Yeah, he's got a nice room. He won't have it long. He left a call for 7 a.m.
See if we can figure out something.
Listen to your phone.
Okay, here we are. My hair literally got messed up in the portal. Let's go, Judge Middleton. Vaughn's laughing. It did though. I was jamming because when I made that intro, I basically made like a double, the part where it goes doo-doo-doo-doo-doo. It's like double. And I love it.
On time. I guess on time. Regarding damages. We're here in a continued hearing regarding damages and the amount of Frank in the matter of Frank and Karen Roberts versus Shelby and Chester Parr. The file number is 24761LT. This is a continued hearing from the hearing we held. First hearing regarding possession was in June. We had a damage hearing on August 9th, and I'll speak to that in a minute. At that time, Karen and Frank Roberts were here live, and Shelby and Chester Parr were here remotely. I continue the matter because I went out to inspect the property at 57532 Stolt Road. And excuse me, no,
13399.
Yeah, I got the wrong address. 13399 Coon Hollow Road, Three Rivers. And I want to thank everybody. You did that all on short notice. I would call it more of a viewing than an inspection, but Mr. and Mrs. Roberts were very gracious. Mr. and Mrs. Parr were very gracious. And whoever was moving into the house was also gracious to get out. I am familiar with the house. I've driven past it 1,000 times or more, but I've never been in it. And so we stopped everything on that August 9th date, and I went out and viewed the premises, which was helpful. But by that time, it was well into the afternoon. It was too late to come back to court. I attempted to schedule this for Wednesday, September 4th. And I was unsuccessful. I don't know. Eventually that case there was a criminal case set for that day that I hoped would settle. And I kept asking in advance if it would settle so I could use that date. Problem is it didn't settle until that morning. So then the whole day ended up being blank. So we found other things to do. So we set it for this afternoon. This is a hearing for supplemental damages by Frank and Karen Roberts, and a cross complaint for damages from Shelby Parr and I'll call him Chester Parr. The complaint by the Robertses asks for $10,825 minus the security deposit of $1,200. And then adding in court costs, they're requesting $9,854 in damages. And I was struggling to give some clarity to those numbers. We didn't get very far. Usually the easy part is rent. We didn't even clear that one up. Rent is alleged to be $3,250. They claim garbage disposal of $2,496.41. Replace windows, doors, smoke detectors, other $4,055, and other was $1,023. They did provide some other documentation, which frankly I had a hard time sorting out. They paid themselves to do some of this work through their contracting company. They contracted with their granddaughter, their granddaughter's husband, for some of the quotes. There were a couple of things that caused my concern in the middle of the hearing. One is there's a basic covenant of habitability that a landlord has when they're renting a property. And this property is certainly deficient, but I wanted to make sure that it didn't violate the basic covenant of habitability. I mentioned this morning, I went out to do a viewing in a case once, not too far from your neighborhood, out on Ash Road, and it was raining, and the rain was running inside the walls in this trailer, just in sheets. That property violated the basic covenant of habitability. This one doesn't. It certainly has deficiencies. It's an old farmhouse, probably more than 100 years old. It is outside the city limits of any city or village, so it's in Fabius Township where they don't have a housing code. So this would not, and I said this, after looking at it, you couldn't lease this house in its current condition in the city of Three Rivers or Sturgis. It would not be code compliant. There would have to be some things done to make this house rentable. Nonetheless, it rented for more than $1,000 a month, $50 every $250 a week, or $500 every 2 weeks is $13,000 a year, which is more than $1,000 a month. The Parrs lived there for 5 years. And as soon as they moved out, the Robertses had a number of people who were ready to move in. That's the condition of the housing market we're in. There are numerous people that would be willing to pay $13,000 a year to rent this property. It's a standalone farmhouse. There are some outbuildings. I don't think anything would qualify as a garage. The Robertses' property surrounds this house. There's a large cornfield. The Robertses have a large garden, which looked to me like a full-time job just in of itself, but there was a very nice garden. So the Robertses would have occasion to visit the property regularly and tend their garden. There's also probably hundreds of thousands of dollars or millions of dollars worth of pole buildings and farm and construction and earth moving equipment. But that's not part of the parcel that is the house that's rented. That's a smaller lot that is surrounded by all the other property that the Robertses own out here on Coon Hollow. So I stopped the proceeding in the middle of it. I was struggling with the numbers given to me by the plaintiffs. hadn't really got into what the defendants had. So first thing I'm gonna do, we'll start all over again. I'm gonna ask everyone to please raise your right hand. Do you all swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes.
All right, I'm gonna try to finish this matter this afternoon. I don't have the luxury of spending 2 or 3 days on a landlord tenant damage case.
Thank you.
So I'll see if we can get to the finish line. All right, let's refer to this, the supplemental complaint for money damages, the basic document we started with. And then it was supported by this document, which had some numbers on it, which I was trying to sort out. So we started with the rent figure, $3,250. The plaintiff contended that they were substantially behind. There was an issue about when they actually vacated. And there's a giant lockout law issue. It appears that the supplemental complaint was filed April 30th. The plaintiffs gave the defendants a notice to quit, 7-day notice to quit, effective April 30th. They were served with the lawsuit, summons and complaint for possession of the property on May 6th, excuse me. There was a hearing set for June 28th. I think the date was June 4th. At any rate, one day in early June, the plaintiffs came to the house, were in the process of changing the locks and removing property. They were informed that the power had been shut off and they assumed the defendants left. We didn't have a court hearing yet. So they were changing the locks to the property before we had the court hearing. And if I understand it, Mr. Parr and Mrs. Parr either got arrested at their own house or at least handcuffed and taken out of there on early June, June 4th or something. And then I think.
It's May 3rd, yeah.
What?
May 13th.
May 13th.
Day after Mother's Day. It was a Monday.
Right, so May 13th. All right, so the notice to quit was for April 30th. By May 13th, the plaintiffs were there prepared to change the locks and the defendants got arrested at their own house. Then Shelby apparently gave notice that she had vacated June 12th. So we're in the strange posture that the plaintiffs called the police, had the defendants arrested at their rental house, and then they're charging them rent for that period of time when they contended they're unlawfully, so that they got arrested by the police. So let's go back to see if we can agree on a rent figure. We didn't even get very far with that, but that's the easiest thing to resolve. And I was looking at my notes from the previous hearing. So, Mrs. Roberts, just as rent, let's repeat, you're asking for $3,250 as rent from when to when?
She was behind when she was notified.
You're gonna have to keep your voice up so it goes on the
So
recorder.
I have Parkinson's.
I know you
can't
do,
talk too
and I
loud.
appreciate that, but we have to try to get it on the record.
She had a balance of $805 on April 4th. And excuse me, wrong year.
Back in January, it was behind us, you know, just
Yeah,
handed out from Johnson Hospital. Back in January. When did you write down? Figured she still owed you till she got out of it.
she paid, since March, she paid $1,000.
All right, this isn't that hard of a question. I'm gonna ask this every single time. She owed $3,250 in rent from when to when? How did you calculate that number?
The last she paid rent was May 7th.
Did she owe
She owed May 7th, 2,900.
All right, that's what I wrote down the last time. The problem is I'm not sure I even trust that figure.
I found the discrepancy.
All right,
The moving out, where she took her belongings, except for a car and 2 dog kennels, was on an earlier date in May. And I think when she notified us, it was June 12th.
right. So she didn't move out till she notified you.
She
You-
didn't move, yeah, she had everything out. but-
No, you filed a lawsuit and you set a hearing for June 28th. You are renting this property and you rented the other property. You don't understand the Landlord-Tenant Relationship Act. You're not willing to hire an attorney. If you had hired an attorney, you got millions of dollars worth of equipment out there, and you're not willing to spend enough money to hire an attorney to help you with this. This case would be over a long time ago. She didn't, under the Landlord-Tenant Relationship Act, when they move out, they have to turn in the keys and give their forwarding address in writing within 4 days. You don't come over and look at the house and decide, well, they must have moved out. You had filed a lawsuit and she had a court date of June 28th.
The electric company called.
All right, well, so I'm aware of that too. Michigan Electric had shut off the power. That apparently got turned back on.
I turned it on.
All right, but they had not told you that they had vacated and they had a court date. You don't understand the rules to
No, I
the,
didn't
to
at
the,
that time.
to the process you're involved in. And then you came there and they came back, you were changing the locks. They got arrested. I'm outraged by
Had
that.
Nothing to do with us. That was on another issue.
Well, that's true.
That was
That's true.
Nothing at all.
All
to
right,
do
that
with
is true.
We called the
Did-
police because she had threatened us.
Yes, all right. All right, so let's go back to the fundamental question. How do you determine that they owe you $3,250 in rent?
Because it was so much a week and we hadn't been paid since April 10th, April 19th.
All right, now you don't have a lawyer.
No,
You can afford a lawyer, but you chose not to hire one. You're the plaintiff. You have the burden of proof. And I'm acting as your lawyer. I'm asking you, what did you do here? Or what did you do here? Or what did you do there? Instead of just saying, all right, Mrs. Roberts, tell me, it's your case, get up, you're under oath, tell me why you think you owe all this money. I don't want to act as your lawyer. I don't want to tell you how to do this. And it makes it difficult. And to some extent, it's unfair to the defendants. So let me ask again, tell me how you got $3,250.
But we were notified. Whenever I set that hearing date first time.
When did she move out? What day?
She- I-
Well,
When did they shut the electric off?
you told me that
It was almost
through,
That time.
through May 7th, she owed $2,900.
Yes,
All right, how did you get that figure?
because she hadn't paid any rent since April 19th. And at that time, she owed $2,400. She gave us $500 on March 28th and on April 19th. And that was the last we got in rent.
All right, so April 19th, $2,900. And that you charged rent through when?
Well, she was supposed to pay until we got the house back.
All right, so this rent was charged through what date?
June. No. it's not.
What I had was it was through June 22nd or June 28th. I think it was through June 28th.
Okay. And then we credited her with $900 that she had paid us prior to moving into the last month's rent. So it was up to 4,100. We credited her the $900 and it came down to 3,250.
All right, the rental agreement, again, you can afford legal help. And we had that very difficult case previously. You got some rental agreement, was typed out on a typewriter and scratched all over the place and on the back of the summons and complaint. It says here that the security deposit is $1,200.
And that was credited on this.
All right,
form.
later, and then $1,200 for the first 4 weeks and $900 for the last 4 weeks. The math doesn't work. 250 doesn't divide into 900. But so they got 900 that you took off the rent, and then the 1,200 you plugged in under security deposit.
Yes,
Okay,
the 900 was because when she moved in, that was 4 years earlier, 5 years earlier. And then that's what it was at the time. But now.
I see. It was, the rent was less. Okay, got it. Okay, so she had a security deposit plus a $900 and you credit the $900. All right. Miss Parr, what do you believe you owed on the date that you moved out?
I believe we owed just if you look at the document in 2024, April 19th, that's the last time I paid then. But
All right, no, let me go back to that.
I agree that we didn't pay from April 24th on till the 12th. There was no receipts given, so kind of hard just to know exactly where they're getting these figures at.
All right.
I believe we didn't have anything.
Well, as
until
of
after we stopped
April
paying.
27th, it shows the balance is 0, but that's 2023.
Yeah,
and
I'm looking
so-
at 2024.
2024, let's look at that one.
I believe we owe $1,750 for rent. Minus the 900 for the last months, and then whatever that balance is, I believe that's what we owe.
Now, she says, it's hard to read it, but rent due, and then it shows balance 0, total balance due 2,400. So she said what she said before, as of April 19th, you owe $2,400. It's your position that you owed 0 as of that date?
Correct, because my question is to them, that's the time they wanted us to sign a new lease. If they're so far behind, why'd they want us to sign our contract? for another year.
I don't know the answer to that.
Yeah,
Her version, her
so-
version is you wouldn't sign a new lease and your
Because they wanted
version.
to up the rent again, and he just was like, no, it's,
All right.
Not worth it.
yeah, the property unfortunately, I mean, it's
All
not
right,
worth it.
April
Needs some-
24th. That's a Wednesday. What day was the rent paid?
It mostly Wednesday or Thursday.
I'll use Wednesday.
When I check the
That's.
rest.
2, 3, 4, 5, 6, 7. Is 1750. Minus 900 is 850. All right, the plaintiff contends $32.50, the defendant says $17.50, about half. All right,
When they moved in, their rent was $214. When they moved out, it was $250.
all right, I calculated things at 250. All right, so we've got, at least that's as close as we're gonna get on rent. And we started to go through some of these other things. Garbage disposal, $2,496. You used your own equipment and company.
We don't own any equipment,
Who owns Roberts Brothers Excavating?
my boys.
Okay, so it's your sons have the business now.
They traded work.
Say that again?
My husband did some things for them over at their farm. And they did that, and that's what they would have charged anybody for that job.
Right.
I didn't-
Terry and Larry Richmond are landlords that represent themselves quite often here in St. Joe County. They would have done this for $500. I don't know. You've got a front end loader at 3 hours at $200 an hour, $600.
They worked hard that
Stop.
day.
I'll give you a chance to speak. This is my turn. You've been
Okay.
interrupting me a lot,
Sorry.
and I'm gonna ask you to not do that. I'll certainly give you a chance to say everything. So you hire a trucking company that brings in a front end loader at $200 an hour. Then you have a quad loader at $140 an hour. You're paying your laborers I guess $25 an hour. And so it became very expensive. Now, I question whether you actually paid this. I think this is how much they billed you to do it. I don't know. Did you pay them
I'm
$2,166?
working it out for them.
Or you did work on the other side?
Well, yeah, I've been a tinker now. They got a old drag line and they got some different programs going. And I'm trying to get even with them. I still owe them some yet.
All right, so that is the 2,496 portion of the complaint.
She could have cleaned her own mess up.
Yes, certainly, she could have. All right, then we get into the next part. which I struggled with, and part of the reason why I wanted to look at the property.
I gave you receipts, didn't I?
Yes, there's lots of them here. Now, when I saw the property, it was mostly clean. The upstairs bedrooms were empty. The carpets had been cleaned. There was no furniture in them yet. It looks like they had a pallet or something set up on the floor for downstairs sleeping, but it looked like somebody was either moving in or moving out, but things were basically pretty clean. In your description of it, there was cat litter and cat feces all over upstairs.
Even on the windowsills.
And it was horribly messy. And nobody likes that. And so we've got this other stuff, replace windows, doors, smoke detectors, other, which included a lot of things that we were talking about on the inside of the house. So you have a quote from Jonathan Hagan, who is your granddaughter's husband, for $3,105. You have Clearview Glass for $325. You also have I did see that someone had shot BBs or pellets through the side of the one of the steel pole buildings, very nice buildings.
And he offered to pay for that. but he
Yes.
never got that.
Again, that is outrageous. They probably could have just been plugged with a piece of caulk or something, but that would be $312 to $395. Some of the things on Mr. Hagan's quote are things that needed to be done anyway. Removal of existing, installation of new doors, drywall repair, chimney repair. The chimney upstairs was all broken. It had plaster on it, but it's probably 100 years old. There were some issues with the doors. They were all intact when I was there, front and back, but they were old. And so anyway, to replace the windows, doors, and some other property, drywall repair and other stuff was $3,105. There were some broken windows, and Mr. Parr, I think, acknowledged that his
Yes,
son
my son's broken window upstairs.
broke the windows. And that's certainly understandable. So that one is $4,055. I guess we add up Mr. Hagan's quote of $3,105. Clearview Glass of $325. The steel building, we'll go with $312. Jackie Hagan had a cleaning bill in here somewhere. Oh, what I did with that. Here it is. It isn't. All right. It is $450 to $750. Clean the house, 15 to 20 hours, 30 to 40 hours. So we'll just say $500.
I believe that included the carpet shampoo and stuff too.
You're still doing it. This isn't a small claims case. It's a general civil case. And so the rules are more precise. Then we've got other, $1,023.75. I forgot what that one was for. Is that all the receipts of like paint and stain and that sort of stuff?
That we had, it was light bulbs taking them,
Yes.
putting them back in. I don't understand why people steal light bulbs.
I had a friend in California who recently passed, and he rented 126 houses. And very often people would take every light bulb. They take the light bulb out of the refrigerator. They take the light bulb out of the stove.
Must be desperate.
At any rate, what is other? $1,023.75.
I'm looking.
Somebody's probably mowing the yard and
Yeah, mowing.
cleaning up dog crap and filling the holes in, and I think cleaning up that burn. Some of that.
Well, it may be, but you have to give me some help on specifically what it is.
I don't know what kind of receipt you're looking for. That's probably what I and Granny charged him for cleaning up the, things around there. Boys hauled up all the junk away and stuff, but they wasn't gonna dig around in the dog filters and clean up crap where they dumped it here and there and mowed the yard, I think. If you save the yard, you mowed it a couple of times with a brush hog, probably 2 foot high.
The neighbor moved it.
Neighbor felt sorry for me there. He come over and mowed it one time, trying to help us keep up with it.
Yeah, it was.
So I'm not clear what other is.
Carpet shampoo, light bulbs,
Like,
paying the neighbor for mowing. It's anything that didn't fall under the other category.
all right.
I know that sounds big, but all the receipts are there.
All right, let's talk about those items. I'm going to defer to the two of you. Who's going to speak? You are?
I can speak, yeah.
Yeah, well, all right. They've got extensive cleaning from Jacqueline Hagan. That one's not really totally out of whack. Not unreasonable rates per hour for professional cleaning, and there was a lot of cleaning to do. The repair work, doors, some other items. What do you wish to speak to those items?
I believe I do. My son did bust the window upstairs in that 1 bedroom, but as you even seen when we went through our walkthrough of the property, none of these things were done. Like those are the same doors that I walked in and out of for 5 years. That's the same carpet I walked on for 5 years. There's been no repairs done. He's just quoting these things and trying to give them cash. My family.
So all the things that were there on this quote from Mr. Hagan are the way they were when you moved in.
Yeah.
Shelby Parr, is there anything you want to tell me about that?
We have a witness too with us that could
I
state
understand.
that. So, one thing I want to bring up about the garbage disposal, and as Mr. Roberts just stated that he traded work for it. So if he's trading work and not money for it, then I don't understand why we are being paid with that enormous bill. Some of the things that were supposedly disposed of, when we did the walkthrough through the property, I saw some of the things that we did leave, that the carpet, the rug upstairs, and a couple of furniture were still there. So they never disposed of that, the actual other tenants are using it, which is fine. We know that the house had some issues when we moved in, and we worked around it. But those issues were there when we moved out. They never fixed anything. The chimney upstairs was still like that when we moved in. And they were saying that they're charging Mr. Hagan's quote for that, but that still hasn't been fixed, so. I just feel like that he's just trying to line his pocket and not being reasonable. These are prices that maybe they can afford, but we're not the Roberts.
All right, well, let's back up a little bit. Let me get some more fundamental stuff. You guys had a rental relationship for 5 years.
Yes, sir.
They would come to your house almost every day.
Correct.
You were on good terms. They probably
Correct.
brought you Christmas cookies and that sort of thing. You'd been on a friendly basis with your landlord for 5 years. What made all the wheels fall off in the spring of 2024?
They wanted a new lease and we couldn't afford to go up anymore with what we were paying in rent. We tried to negotiate my wife tried to negotiate a new lease with them. They said they would get back with us. And when they got back with us was the day that he served me a eviction notice at the front door.
Now, in your correspondence that you filed, you indicate your financial issues. You had garnishments from work, you got stuck with a car that had been co-signed with your ex-husband, and you
Yes.
were paying on that.
That was all years past, like.
Right, so that wasn't at the time of this.
Correct.
Well, it certainly went haywire because you left the place in a mess. You were in defense of them, even though you didn't tell them you moved, the house was mostly abandoned. Nobody was mowing it, nobody was in it. You weren't paying any rent, but you still wanted to maintain some dominion over the house.
We still
And-
have, we were trying to get
I
rid of
was
that
trying to get
car
rid of
and
my
get a
car. I just
trailer over there to
didn't
get
have
the
an
car.
opportunity to get a car and a
So
trailer
it's
at the
just
time.
financials and time.
And so that did cost them expense. If this had been done correctly, and they had come and you'd gone through an inventory checklist together and you'd have given them your keys and your forwarding address, they could have taken possession of the property, got it cleaned, re-rent it. As it was, they lost rent at very least from April through June. And were unable to re-rent the property. Now, by the time I was there in August, they had another tenant in there, and according to the Robertses, they had people knocking on their door who wanted to rent it. So that's fortunate that they were able to re-rent it. As I said, you couldn't rent it in its current condition in someone that had code enforcement. All right. You filed a counter complaint. So we've heard from the plaintiffs. You're suing them for $7,071. And it's easy to make a lawsuit. It's hard, maybe harder to prove it. Now, one of the things I wanted to see was the water. The pictures that were provided to me by Mrs. Parr and are part of the record show the sinks and the shower, which were very corrupted by very hard water. Now, bear in mind, these are the pictures that the defendant gave me, rather than the plaintiff. Now, all of these were cleaner when we visited the house. The shower stall was not that bad, and the sinks weren't that bad, but they certainly could be if you didn't do constant maintenance. So at the time these pictures were taken, that was the condition of the bathroom. Now they were cleaner, but the problem is that this property has very, very hard water. I tasted it. And there is some sort of a water softener and osmosis thing downstairs. I'm not sure if that was that there when you were there.
It got put in when, like the last year that we were there, the softener, and that was just it. We had a new softener and a new water filter after, but that's, we had to complain and complain.
All right, was the water filter there when you lived there?
No, there was.
Was before you moved out, did they put in that
Yeah,
big
that,
water
yeah.
filter?
Yeah.
Okay, and when was that?
So probably within the last year and a half.
Back in 2023, about the
Yeah.
springtime, right around the time we signed the new lease again. Every time we sign a new lease, they want a new lease after they did some type of project, and then they up the rent.
All right, so you're suing for 2 cases of water a week for 5 years. $1,825. You're suing them for garbage disposal. Had to get more, what's that about?
When we moved in, there was like, they're saying we had left a lot of crap there. When we moved in, there was 2 truckloads of wood on the front porch. There was crap all through the house. There was the whole garage, the couch that was there, the table that was in the garage was still there from the one that we moved in. Like, there was so many things on the property, and that's why we brought a witness today that was there to help us like clean it out. They never gave us dump passes to remove any of the property, so we had to remove it ourselves.
Cleaning supplies due to severe hard water and 3 washing machines. The washing machine sits out on an unheated porch, washer and dryer. I would have thought they would be very prone to freezing up. The rental agreement requires that the plaintiff, or let me look at it, that the defendant heat the
That porch is heated.
basement. Pipes have been known to freeze, so the tenant has to maintain heat in the basement. But apparently they heated that porch also. All right, so tell me about $500 for cleaning supplies due to hard water.
They sued for cleaning supplies for iron out and that type of thing. So honestly, that's why I put it in there. If they're trying to ask for it, then I'm gonna ask for it because we had to buy it to keep somewhat of the stuff under control. As you can see, if you don't stay on it, it can get pretty out of hand.
Yes, and the question I asked before is why did you stay there? It was this terrible. They
We
were
didn't have
that
anywhere else
terrible.
to go. It was
Well, I
right
didn't
before
finish
COVID.
asking my question yet, but they didn't make you stay there. They would have said at any time in these, hey, if you don't like it here, feel free to move. We've got somebody else that will rent it. So you chose to stay there under the conditions it was under. So that's an issue also. Replacement of clothes. Had to replace numerous pieces of clothing and towels. Same sort of thing, all the hard water, and that's just the estimate of what that cost. I think there were some pictures of what it had done to some of the clothing. They made us pay back to fill the propane tank from the last tenants leaving empty when they moved. I'm not sure I understood that.
I think we actually ended up getting rid of that after our last court date because they said they gave us credit.
All right, so that's
that.
not an issue.
So that shouldn't be an issue.
All right, you have a witness you want me to hear from?
Yes, please.
All right, why don't you come right up into the witness box? Well, it might be easier if you come into the witness box. You're gonna be a witness. Please raise your right hand. You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief. Thank you. Please have a seat. Would you state your name?
My name is Sandra Fuller.
Could you spell that for us?
Sandra. F is in Frank, Uller.
And are you friends with Shelby and Chester Parr?
You could say that. That's my daughter and son-in-law.
Okay. All right. What do you know about this?
What I know is when she moved into the place, she brought me over there. The first thing I noticed when I pulled in was the mailbox was like not even, it was crooked and the mailbox, the door was off. So that right there, it's like not even safe. When I walked in and saw like the stains from the water, there was the door to that front porch area, it was like a hole this big in it. I mean, animals could have came in there and stuff. There was crap all over in those sheds in that garage. It was not even theirs. They weren't even moved in yet. So they had to clean all that out. They said that Karen and Frank said that they would make some kind of deal that if they cleaned it out, maybe they could take it off the rent or something. So they were gonna give them dump passes, but they never did. So we supplied dump passes because we live in the same county, so we just gave them the dump passes so they could haul all that stuff out.
What year was this?
2019.
All right, what else would you like me to know?
It was right before COVID. So I think after COVID happened, it's kind of hard, like housing and stuff like that. That wasn't, I don't think this, I mean, Buddy and her are trying to like buy a house. So, you kind of got to take what you can get sometimes. And that's it. I mean, to be honest with you, when I saw the house, I was just like thankful they weren't trying to buy it because that thing is way too old. It has so much stuff. The electricity scared me. I mean, it's sketchy. My granddaughter was like, couldn't even sleep in her bed because she was getting stung by bees that were in the walls. And so she had to go and sleep in another room. I mean, that to me is it's just wrong. I mean, the landlord should have done, they didn't clean like they said. What I as a witness, I saw all the stuff in those sheds. Those whole outbuildings were full of junk. That couch, there was tables, there was stuff piled all over. The house was a mess in there. I mean, she had to like clean for probably a week before they could even move in. It was shocking to me, honestly.
Well, the buildings are clean now.
I'm sure they are.
And again, it's an old house. One looked like an ice house or like a butter and milk storage building or something. And I don't know if any of them are big enough to put a car in, but there were several outbuildings that they were pretty empty and clean at this point.
The basement, and that was another thing. It was like, when we went down to the basement, there was water standing, and then the door to the outside of it, you could see underneath it. I mean, water could go right down into that basement. There was mold. It's like, my granddaughter has allergies and stuff. It's just not healthy.
But you can still see daylight through that under the door from the
Yes,
basement.
I don't know. It was like, we tried to help buy like stuff for the bees and like this stuff called bifin that you can buy and like try to help them out with that. But I mean, it gets expensive when these things are in the walls. I mean, they're chewing hornets or something. I mean, it's not good. That's probably why nobody's sleeping upstairs, I'm thinking.
I don't know. Like I said, it looked as though somebody was moving in. All right, so this is in the early part of when they moved there.
Yes.
And again, they chose to stay there for 5 years. That basement, it looks like something from about the time of the Civil War.
Yeah, it's scary.
But it does have a modern water softener and some sort of a water purification system, and there's a furnace down there, but really nothing else. In fact, I think it has a dirt floor.
There was, yes. I remember there was so much junk in that basement though that you had to move out. That
Well,
they did. It was.
The basement was, there was nothing in it at the time I saw the property.
Yeah.
All right, what about at the time they moved out? As I indicated, they'd had a good relationship with the Robertses for years. Robertses had cut them some slack on their rent, had worked with Shelby's employer to get some emergency assistance, had been on friendly terms with them. What happened in the spring of this year to make all that go haywire?
I think because they didn't want to stay there and pay the rent. They couldn't afford it, so they had to find some other place.
Well, as you heard from the testimony, they immediately re-rented it.
Yeah,
Um,
it's just, what, I don't understand either why they changed the locks in May, and until they had till June. So if the house was left, if there was cat turds and all that up there, they didn't even give them a chance to get in to get it because the doors were locked. So
No,
how did
this-
you get in
this-
to clean it?
This was after they left. This was after June 12th. That it was left in that poor condition. All right, is there anything else you want me to know?
Nope, I just wanted to let you know what the condition of the house was and what they had to do. They had to clean all that stuff out. So what they're claiming that they cleaned out was from the former tenants. It was still there.
Well, it is cleaned out now because those buildings were clean when I saw them.
I'm almost thinking that they didn't check with the last tenant before they moved in. They just rented it so fast that they didn't care. I don't know. I don't know what they were thinking, but it was not, it didn't look like livable condition to me.
Well, let me tell you what the law says. There's a basic common law theory called that every property should be habitable. And there is something called a covenant of habitability. It has been institutionalized in Michigan under the landlord tenant law under MCL 554.19. And it says, the habitability covenants apply to all agreements to lease residential property. In every lease or license of residential premises, the lesser covenants that the premises and all common areas are fit for use by the intended parties. A covenant that they will keep the premises in reasonable repair during the term of the lease or license and comply with the applicable health and safety laws of the state and local unit of government where the premises are located, except when a disrepair or violation of the health standards has been caused by the tenant's willful or irresponsible conduct. That's essentially it.
Okay.
It shall be kept in reasonable repair and comply with all applicable health and safety laws. All right, thank you. You may step down. Well, before you do that, Mr. and Mrs. Roberts, do you have any questions for Ms. Fuller? Anything you'd like to ask her?
Hi, Sandy.
You got a question?
I had one, just a minute. Were you aware that Shelby moved in the day she rented the house and she said she would do the cleaning of the house?
Yeah, I was worried she did.
Well, she wanted to move in and said that she would do the cleaning. She moved in after dark. That's how anxious they were to get in.
If I have to do anything.
Well, just to
It
answer
has
the
to be-
question, don't have to, and that is apparently the way it did. The other tenants had barely moved out. They were desperate to find a place to live and they ended up here for 5 years.
I think they were excited actually because they
I think
they knew
were
the
too.
people that they were renting from.
I
It was a
excited.
country location, but the house was not something that I would rent, Karen. I'm sorry. I mean, I was, you know, you
that
can't
it
tell
was
your
dirty.
children what they can and cannot do. But
All right, well, I don't want to have you guys have a discussion about it. You can step down, thank you. All right. We're still on the defendant's half of their counterclaim. Miss, I want to call you Kimball, Miss Parr, is there anything else you want to tell me?
Just the, are we just working off of this form still right now?
Yes.
Okay. Not really.
Well, you've got there, you showed me where the bees were right inside the wall.
Yes,
And you've got bees medical expenses for your daughter.
yes.
I'm not sure those are, how much of this is recoverable.
Yes, I had to take her to the emergency room after she got stung on her hand twice and it turned into cellulitis. So that was just our out-of-pocket expense that we had to pay for deductible to go to the emergency room that day. And that's after ordering.
All right, now, after you found out these walls were full of bees or hornets, did the Roberts do anything to remediate that?
Not right away. He just gave me a can of wasp spray and said, try this. Frank did say that they had bees in their house too, and he didn't know what I wanted him to do about it.
Did they ever hire a pest company or anything to come
No,
in?
they did not.
But this wasn't just a couple of bees, that wasn't the whole wall full of bees?
There was hundreds of carcasses after we would spray that wasp spray in that front porch that you saw. We had to keep everything sealed off. We had to put like a garbage bag over that window that they said was broken, that was never there. We had to put a garbage bag over it just to keep the bees somewhat contained. And my daughter had to move bedrooms for 2 months. And you saw the tape that we had in her room over the holes trying to somewhat contain it. But they were really bad.
All right, anything else you want to tell me?
No, that's it.
All right, anything you wish to say, everybody's still under oath, in response to her complaint, her counter complaint?
Yeah, I would.
All right, what would you like me to know?
We went over there, there's a little hole on the roof of the kitchen, you know, that's a flatter roof, but it's closer to the ground. There's a little hole where it's going in and out. And I got up there, I sprayed that good and I plugged that hole. And I don't know, you know, I don't have any control of bees. Well, that's one thing, you know, she said anything she complained about, we try to take care of it. And I don't care what she says about moving out. I'll tell you why she moved out, because she had to. She didn't want to move out, and I'll tell you just what she said. Buddy there said if we didn't come over and give her a notice of them leave. In the meantime, she come over talking by herself. And she come over and she was supposed to pay, she's supposed to get a good relationship. Runs in the hospital. She had some kind of a plan there that she's gonna get a handout. It started out about 1,600 or something before she, you know, she kept putting us off. Then when it got up, I was telling you that the other day, it got up in the 20 something. Anyway, she said, well, we're gonna get that in a few days. I don't know whether she got it or not.
Are you saying that she needed a formal notice to quit before she could get help from the hospital?
No,
Okay,
no, she didn't make the letter. Hard luck, you know, she said that in her letter. This is about the third time she did that. We had to sign it saying that when she was gonna get evicted, you know, that was the deal, I guess. So we signed it, yeah, she's gonna have to move unless she gets this good, you know, this handout. Well, that's what she come over, this, I don't know, she never did tell us where she got that, I don't know, 2,500 or whatever it was. Anyway, I told her she's gonna, you know, have to try to get caught up. She's been behind for the last couple of years, you know, off and on. I said, you probably have to find another place. And she, you know, in the past, she said, well, maybe my mother let me move in with her. Anyway, coming down, she got mad.
what's the time frame of this that you're talking about?
Well, just a week before I gave her notice to move. She threatened Granny. She said, if you make me move, she said, I'm gonna make your life miserable. She said, I'm gonna go out of my way to do it. And so that's the only way she could do it, is tear up the house and make a mess. And she said, I'm not gonna pay him, I'm not gonna sign a lease, I'm not gonna pay him rent. She said, because I know you got the place paid for. And I said, what's that got to do with anything? And she said, the judge is gonna give me 9 months free rent because I got a 12-year-old daughter. That's her very words.
Well,
So
that's
she didn't
not-
wanna move. She didn't wanna move. I and Granny ain't up to getting threatened like that. You would have did the same thing. I don't need somebody in the house, if they
All
threaten me.
right, so you said you're probably gonna have to move, and then that was her response, and then after that, you filed the notice to quit.
Yeah, that's what the pastor. What would you did? Somebody threatened you, you wouldn't put up with it, would you?
Probably not, but no, I get to ask the questions. All right.
Okay, well,
At any rate, this tenancy had to come to an end,
I think so too.
for the sake of both sides. You've got your garden out there, you're going out there all the time. You want to be on good terms with your tenants. For the tenants, they've got their landlord there every day, every other day, and they want to be on good terms with them. And it worked for a long time, until it didn't. Everything in there, when I saw, was old. The carpet was old, the woodwork was old, the doors were old, the flooring was old. The bathroom was old. The sinks, there wasn't anything new in there. Maybe, I don't know what the newest thing was, maybe the 1980s. And the new people seem to be trying to make it their home. It was cleaner. All right, now let's talk a little bit about one other factor here. This isn't exactly clear, but there is something in Michigan known as the anti-lockout law. It's found under MCL 600.2918. It was enacted in an effort to prevent landlords self-help in executing evictions. The statute prohibits the unlawful interference with the tenant's possessory interest and specifies what constitutes unlawful interference. The provisions in that statute may not be waived in the lease. In fact, the lease prohibits the waiver of those factors. A tenant may bring a suit against an owner who forcibly and unlawfully ejects the tenant from the leased premises. Unlawful interference includes, I'm not saying these were done, but this is what's in the statute. The owner uses force or threatens to use force. The owner removes, retains, or destroys the possessor's personal property. The owner changes or adds locks or security devices to the premises and does not provide the possessor with a key. The owner boards up the premises, which prevents or deters the possessor from entering the property. The owner removes doors, windows, or locks from the premises. The owner causes by act or omission the termination or interruption of an essential service, like shutting off the power or the water. Here, as I understand it, the power was shut off because the tenant didn't pay the power and the landlord paid to turn the power back on. So, Ms. Parr, how did your power come to get shut off?
Because if we have to pay every day, it's a prepaid thing. So once it runs out and they shut it off
You pay for electricity
every day.
one day at a time?
Correct. It's a prepaid meter is what MEC had us do for that property.
you could pay like a couple $100 and stay on for like the month or whatever, but it would
Once
eventually.
it's depleted,
yeah.
it turns off.
Like a
immediately.
prepaid
All right,
phone.
now, in defense of the landlord, you guys were in the course of moving out.
Correct.
They filed for a court date. And you weren't gonna pay any more rent. So the longer you stayed there, the more money they were out. So they served this lawsuit on you. You had a court date of June 28th, I think it was. And in the meantime, you moved most of your stuff out. There were some dog kennels and some other things, and the power had been shut off. I've never heard of people paying power day by day. So you were mostly gone. The power was shut off. You hadn't turned in the keys. You hadn't given them your forwarding address in writing. And you weren't gonna pay any more rent. You were gonna wait around till the middle of June to get your stuff out of there and maintain dominion on the property. In the meantime, they didn't get any money. In fact, never did. So they come over there, the grass is 2 feet tall, the power's shut off. Most of your stuff is gone. It isn't unreasonable to assume that you had moved, but there was a lawsuit pending, which had a court date on it. So if they'd had a lawyer, their lawyer would have said, don't do that. But they did it. And he ended up, you quit mowing the lawn, you quit paying the electrical, you left a few things there, but you want to say, hey, it's still our place. So there's, both people are in the wrong in that circumstance. But as a, under the law, at that point, he didn't have the authority to change the locks. So what happened on the day that he was there to change the locks and you guys came back to the house?
Yeah, we came back, it was May 13th, day after Mother's Day. He was already there mowing the lawn and the locks were already changed. We went to the property to get more of our items. That was our whole intent that day. And then we both called the police. I called the police and I guess he did too, because we didn't know what was going on. Why is he in our house? This is still our property. He ended up having to, he left the house unlocked after that day and left the key that they changed it to in there. So I was able to come in and go.
All right, so did you get arrested that day?
We both did on a previous incident that we did not know we had a warrant out for arrest.
Well, let me tell you, I knew it was out for like 2 years.
No, we did not.
And I got a stack of domestic violence, unserved domestic violence complaints. Now, ultimately, the charge was dismissed.
Correct. And so we were.
But there was a warrant for your arrest for almost 2 years. The officer got it, you never moved, you were in the same house,
Yeah.
and nobody bothered to serve the warrant.
No.
And I kept waiting for the other shoe to drop. I had about a dozen unserved domestic violence complaints that I looked up and was concerned about this problem. And it's not up to me to say, hey, why don't you go serve this warrant? So what happens, I don't know, they put the warrants in a cigar box, and if somebody happens to get pulled over on a traffic stop, they arrest them. At any rate, so you weren't arrested for trespassing.
No,
You were arrested because there was an open warrant on some other matters.
correct. That
All
we
right,
both
so-
had-
All right, you weren't arrested for being at your
No.
house. All right, then that certainly changes the posture of that. All right. But to go on a little further, he did change the locks before you got there.
correct.
The remedy, the person may claim damages a person who is ejected from the premises by forceful and unlawful manner is entitled to recover possession of the premises and the greater of 3 times the amount of her actual damages or $200. All right. Mr. and Mrs. Roberts, you're the plaintiffs. You have the burden of proof. Is there anything else you want to tell me?
When we found out she moved, we tried to call her several times. She won't answer the phone. Finally, Chester answered the phone and she said, "Are you guys out yet?" He hung up on her. He didn't say yes or no, nothing. Well, I guess that's, you do whatever you want, you know, so we did try to, we did try to find out something, but
And we left the key to the new lock.
yeah. Tried to oblige him.
All right. Is there anything else you want to say?
Basically, we know we didn't leave the house in the best condition, but we also weren't given the house in best condition. We just don't want to be held liable for things that were already there when we moved in. We know that we have to owe something for something that had happened. We just wish it to be a little more reasonable on the cost, but we just don't want to be held liable for some other damages that were already present at the property when we first moved.
All right. I'm going to take a recess. This may take me about a half an hour. I spent some time early in the week looking at these numbers, looking at the receipts, looking at the previous testimony, looking at the covenant of habitability and looking at the lockout statute because I knew it blocked out this time. So I'm gonna take about a half an hour break and I'm gonna make my calculations and then I'll come back in and make my ruling. So we'll be in recess.
Yeah.
What time
What time we should be back at?
3 o'clock.
3 o'clock.
There's enough time to maybe go get a cup of coffee across the street.
Do all her stuff. Different things. He didn't give you a chance, you know. You should have went through that one at a time and, you know, that's,
Gave me a chance
Let
to
us know.
respond. Said it took you.
you know what?
You gave a chance to respond to it.
Yeah, but you know, the whole thing. You know,
Here.
she would change that.
A versus a B, and that carries a maximum of 1 year. That you for vehicle on a public. With Amanda Dawn Plummer. Miss Plummer. It looks like you have 2 cases. They both have traffic designations. The first one is an active warrant for no proof of insurance. It's alleged that on or about the 19th day of January 2024 in Butler County, Kansas, you operated a motor vehicle on a public highway or property open to use by the public and failed to provide proof of insurance upon demand by law enforcement. It's charged as a B non-person misdemeanor, maximum 6 months, $1,000 fine. I think there's, generally speaking, there's a $300 fine that's assessed for this. I'm gonna enter a not guilty plea for you out of curiosity. Mr. Regeer's appearing on behalf of the state. Was there an accident that was involved with that?
Your Honor, in 24 TR 1057, the ticket does appear to indicate in the negative as to whether or not an accident occurred.
Then in 2024 TR 2336, you've additionally been charged that on or about the 28th day of May 2024 in Butler County, Kansas, that you drove while your license was suspended, a driving while suspended, that you have a prior conviction in Augusta Municipal Court in 2017 for driving. Well, it was actually July 17th of 2018 that you were convicted. Augusta Municipal Court for a prior driving while suspended, which makes this a second offense. It is still a misdemeanor, but it's an A versus a B, and that carries a maximum of 1 year in the county jail and $2,500 fine. There is a mandatory minimum $100 fine that has to be assessed and 5 days in jail if you're convicted. Count 2, again, another no proof of insurance. Count 3, a tag violation, that you did not display a legal tag to the vehicle that you were operating. I'm gonna enter not guilty pleas on that as well. I'm not sure why both of these resulted in active warrants, but I imagine it's because they couldn't reach you by summons. It looks like when Judge Webster signed the warrant in 24 TR 2336.
Is that the one with the tag folded up?
She set a bond at 3,000 cash or surety on that one. I'm not sure. This was 1,000. That's a total of 4,000 cash or surety that was set as a bond for you. I'm going to give you an opportunity to speak to your bond, but I do want to give you a court date, and that court date will be November the 18th, 2024. And I'll determine the time based on whether or not you qualify for court-appointed counsel. Do you own your own home?
No, ma'am, I'm homeless. My car is my home.
Okay. And you're not currently employed?
No, ma'am.
Okay. Were you employed before you got arrested or when you got stopped for these charges?
Yes, I have my own personal business.
And what is that?
Dog grooming.
Okay.
I groom out of the car that I can't move.
Okay. Where have you been developing your clientele at?
Word of mouth.
Okay, but I mean, Wichita, Augusta, where are you from? What area are you generally in?
Augusta.
Okay. Okay, well, I'm going to appoint an attorney to represent you, Darren Patterson. My concern, Mr. Regier, is if she can't make bond, she'd be sitting in jail until November 18th, which is quite a ways away. What a bond is for is to ensure that you're gonna reappear and not violate the law.
I didn't even know I had any of this going on. I've never received any paperwork stating that I had court. I've never received anything.
Does she have any prior failures to appear in Butler County that you're aware of, or any charges that we should be concerned about?
One moment, Your Honor.
I mean, part of my goal too, when I set a bond, is to try to prevent anyone from potentially reoffending. And what may seem minor, if you are in a vehicle and you get in an accident, even in a parking lot, and someone gets injured or their car gets damaged and you have no insurance, then it's on them. Or someone gets hurt, you can't pay their medical bills because you don't have any insurance.
It's not
So what I need
understandable.
to ensure not only is that you reappear for court, but that you also don't violate the law or operate a motor vehicle
I'm
until
not,
you're legally licensed and insured.
the vehicle doesn't move.
Did they impound it?
No, no, Ryan Riggins made sure it was taken apart so it doesn't move.
Who's Brian Riggins?
William Ryan Riggins.
Oh, okay, I think somebody we've had in court before.
Uh-huh.
Good.
He has taken apart pieces of the car that we don't know what he's taken apart or taken off, so it doesn't go anywhere.
Mr. Regier, do you have any recommendations or anything you want to state as it relates to bond?
Your Honor, far be it from me to recommend the court modify orders that have already been issued by another judge in this matter. It is the state's understanding that this defendant does have 3 prior failures to appear out of Augusta, El Dorado, and Sedgwick County. Additionally, I am showing prior convictions for driving while suspended, as well as a driver's license violation. I am showing, in response to the court's other inquiries on the issue of service in the 24 TR 1057 case, I am showing a summons, alias summons, and a pluri summons was filed with the court. Most recently, concerning the pluri summons, the return appeared to have a handwritten notation, including, quote, move no forwarding address, with a date served on the return of August 9th of this year.
Yeah, that's kind of consistent with her saying that she.
I'm
lives
in the
around.
same spot. I haven't moved in a year.
Well, what is that spot?
It's 110 School Street, 1110 School Street, where my car is.
I'm sorry, there's a school street in El Dorado. Is there a school street?
It's a school
Augusta?
street in Augusta.
Okay.
That's where I've been. The sheriffs come to pick me up there every time. They know where I'm at.
Is that in the city limits of Augusta?
Yes, right by Garfield School.
Okay. Do you have any other family there?
No,
How long have you lived in Augusta?
40 years.
She doesn't have any felony convictions? Okay, so here's the deal that you need to know now. The courts have come down and said it's fine for law enforcement to run a person's tag. When it says there's a registered owner, they can then check the registered owner to see if their license is suspended. And then they can pull you over. So they don't have to wait till you commit a traffic infraction
The car
to
doesn't
pull you
move.
over to then discover that your license is suspended. So if you get back into a car and they run that tag, or there isn't a good tag, they will pull you over and arrest you for driving while suspended. So it's made it much easier to capture people who are driving on suspended license. And
The
I
car
imagine
doesn't
you've been
move.
doing that for a while. So I'm
The car
really
doesn't
concerned
move.
about putting you back out there and making sure that you don't violate the law and you show back up for court. So what can you tell me to reassure me that if I reduce this bond, you're gonna show up and take care of your court case?
The vehicle in question hasn't moved. It is now a storage unit for my items and I live in it. Other than that, it doesn't move. It's got 4 flat tires and it
Okay.
doesn't start.
Is it registered in your name?
As of right now, yes, I'm trying to give it to my son so they can take it, but I've been told that the lights or the registration's suspended, so I can't even sell it to my son so he can change to him.
Okay,
And Your Honor,
yes.
one more thing I might add
I
is
just want to give it to my kid.
well, I have had the opportunity to review the returns on the pluri summons and the alias summons. Both the pluri summons and the alias summons appear to include the quote, move no forwarding address notation. Additionally, the address on page 1 of the alias summons and the pluri summons appear to refer to the to different numbers, but on the same street and location previously referred to on the record by the defendant, especially the address on the alias summons, which does appear to correspond precisely with the location given on the record today by the defendant.
Okay. Okay, here, this may not make sense to you either, but here's the other thing I'm gonna explain to you. You need to have liability insurance on that vehicle, even if the tires are flat. Because someone could steal that car from your driveway. It goes with the car. And you go, and they would take it and go drive and hit somebody and leave the scene, a hit and run. And there's no insurance on that vehicle, and you would be liable for that.
I totally understand that.
Okay. So, I mean, I guess you're almost in a spot where you, depend on the value of that thing, you.
I
need to go
trusted the
salvage
wrong
it
person to
somewhere.
go to Wichita to get me insurance, and they bought crack instead of my insurance.
Yeah, it sounds like that might be part of your problem, is the people who you trust yourself to or with. All right, I am going to set the bond at $12.50 on each case for a total of 3,000 cash or surety.
So 300 for them to get me out.
Or I guess that makes 2,500. I'm sorry. 1,500 would be 3,000. 1250 would be 2,500.
So how much cash do they have to come get me?
I imagine they're gonna ask you for about $250.
Which means they wouldn't come get me last night for 100, which means they're not gonna come get me now.
Is that what the bond schedule shows it at? It showed 1,500 for both these cases. I don't think it should have, because she actually signed a warrant with an amount. So it was predetermined to be $4,000. That's why I reduced it to 2,500 over the objection of the state.
They're not gonna
I
come.
guess my concern is, Mr. Regier, whoever's handling this misdemeanor docket and traffic, are people just being left in jail for 2 months because they can't meet bond?
I have no knowledge as to that, Your Honor. However, it is the state's understanding, in light of the court's concerns, note on the record that Judge Lee does have an expedited docket next Friday at 1:30.
Well, I know, but these are new cases. I kind of hate to overload him with new cases that.
Friends were under the impression that all they needed was $100 to come get me. If you raise that, then
Yeah, I don't know I don't know where they got that from, but that would not be
paperwork that
correct.
or the paperwork
That's-
that Noel gave him when they came and picked me up.
That's actually a bonding schedule for probable cause, arrest by law enforcement when it hasn't gone through a judge yet.
So they're not gonna come get me.
When a case with all the information goes through a judge and they set a warrant amount, that's the amount of your bond, not the bond schedule. So someone got confused if they told you that, because that's not how it works or should work.
It doesn't matter. They're not gonna come get me, so.
All right, then I'm gonna move your court date up. So scratch the November 18th. I gave you an attorney. Your court date is going to be September 20th at 1:30.
And forgive me, Your Honor, is the court ordering that Mr. Patterson be appointed to both these cases?
Yes.
Thank you, Your Honor.
It's on my fiance's case, so it's a conflict of interest.
Probably not on a traffic matter. Unless you're gonna testify against your boyfriend on a case.
No.
Okay. He'll let us know if there is. You can also waive conflicts if you want to. I don't see how
Can I go back?
you
to
not having a license or insurance is conflict with some other case, but you just have to sort that out, okay? All right, thank you.
Thank you, Your Honor.
Does Jill have any questions?
That court date was for both cases, correct?
Yes, please. Yes, please.
All right.
Both cases, same attorney, Mr. Patterson, expedited docket, September 2024 at 1:30. Lots of traffic today.
Yes, ma'am.
All right, Tina Starnes, you've been charged with you had posted a bond, an appearance bond, and you failed to appear
Yes, ma'am.
on so there's a bond forfeiture bench warrant issued. The bond got set at 3,000 cash or surety on a driving while suspended, expired tag, and no proof of insurance. In count one, it's alleged that on or about the 16th day of February 2023 in Butler County, Kansas, that you did operate a motor vehicle without a valid license. Your charge is a first offense. Class B, non-person misdemeanor, maximum 6 months in the county jail and $1,000 fine, mandatory minimum $100 fine. There is no mandatory minimum jail time on a first offense, only a second offense. The expired tag or registration is unclassified. It's a maximum 30 days, $500 fine. And no proof of insurance is also a B misdemeanor, maximum 6 months, $1,000 fine. Typically, a $300 fine is assessed on this offense. Do you want to waive counsel, enter guilty plea, or enter not guilty plea and speak to an attorney, one that you either hire that's appointed to you, and I will give you a future court date and a bond?
And Your Honor?
Yeah.
In accordance with my duty of candor as an officer of the court, I would respectfully advise the court that it would appear a first appearance was conducted on this case back in May of 2023, and my notes would appear to indicate that Mr. Patterson was previously appointed to this matter.
Yes, ma'am, he was. Now, do I still have the option to waive cancel, or, I'm sorry, waive counsel?
Yeah, we usually have to reassign counsel after that much time has elapsed, which is over a year. So if you want to waive your right to counsel and enter pleas, you may do so. If you want me to consider reappointing Mr. Patterson, I will.
He didn't really do nothing for me, ma'am. I'm sorry, but he didn't.
Okay.
I'm just being honest. Respectfully.
Okay. So I will have to have you sign a form that you understand that you have a right to counsel. The reason that you have to waive counsel is because these are enhanceable crimes. So the next time you get a driving while suspended, you'll have to do a mandatory 5 days in jail. And if you are put on probation, you violate, you're subject to serving your underlying sentence.
Right.
So anytime that there is jail time associated, you have a right potentially to a jury trial. But we certainly appoint counsel if you're indigent and you qualify, if there's any possibility of you being further confined.
Right, I understand.
Okay.
Yes,
All
ma'am.
right, they're gonna show you, and I'm gonna ask you to read through a
Okay.
waiver of counsel. Did you ever obtain, Mr. Regier, in your file, the Department of Motor Vehicle certification that shows that she in fact was suspended and that something was mailed to her last known address?
One moment, Your Honor.
So I was in fact suspended. I was in the process of getting what is that called? It's a different type of license.
Oh,
Restrict-
restricted?
Yes, ma'am. Yes, ma'am.
Okay.
And I can get my restricted now. I just had to wait so long because there was a traffic accident that had initially suspended the license, which I wasn't aware of. But during the traffic stop, I was issued a ticket, but I was taken by ambulance, so I wasn't aware of the ticket. It was a huge mess. Anyways, but because there was a minor involved in the accident, I had to wait so many days after the accident to get a waiver signed. And then I had to track that lady down that had that accident with me. And it was a huge process. But I finally got the waiver signed and the times is done. So all I have to do is go and file for the restricted. That's it.
And Your Honor, in response to the court's earlier inquiry, it is my understanding that I do have a copy of the certified driving record in my file, along with the document previously referred to by the court, if the court is prepared to take judicial notice of the same.
So what do I
Okay.
sign?
No,
What do I do?
as an officer of the court, I just want to make sure before I accept a plea, you would have had evidence of a notice of suspension. You don't have to show actual knowledge, just that she was on the suspension list that was mailed out and that it showed that she was suspended on the 16th day of February 2023. All right. So I've told you the possible penalties. I did advise you that if there is a jail time imposed or a risk of jail time, that you have a right certainly to a bench trial and to a jury trial if you would demand one. And there are certain rights that are associated with a jury trial: presumption of innocence, right not to incriminate yourself or have to testify, right to have an open courtroom, public court hearing in the presence of witnesses, subject to cross-examination by any attorney that you have, and a right to a unanimous verdict, and a right to appeal any verdict, to ensure that you received a fair trial and that none of your constitutional rights were violated. Keeping all of those things in mind, is it your wish to sign a waiver of counsel and waive your right to a trial by jury or a bench trial?
Yes, ma'am. I haven't driven since and I haven't received anything else. I would just like to get this completed with the courts.
Okay, well, I've told you the maximum sentence. I can't guarantee you what the sentence is going to be. You have to be willing to do it, understanding that there is a maximum sentence and if there's a minimum sentence. And I've told you about minimum fines, but there is no minimum jail time that you have to serve.
Yes, ma'am.
But if you go on probation, any of that time that is ordered, if you violate and just skip out on your probation, you could be brought back into court and your probation revoked and ordered to serve your underlying sentence.
No,
Even if you waived your right to a jury trial, you don't go back and reinstate your right to a trial by jury if you waive it today.
I understand. And no, that won't be happening, ma'am, by any means.
Okay.
To jails, I've been in jail long enough. Trust me.
Now you need to make sure that you're not being threatened or coerced or
no.
anything, and that you're of sound mind as you enter this plea today.
Yes.
What is your highest level of education?
Actually, college, fire degree.
Okay. Are you presently under the influence of any drugs or alcohol?
No, actually, I'm sober.
Are you taking any prescription medications?
Ibuprofen, Tylenol, nausea medicine, about the usual.
Okay, nothing that's adversely affecting you?
No.
Okay. Do you believe you're of sound mind and good judgment?
Yes, I do.
Okay, and is this of your own free will?
Yes.
So no one's threatening you that if you go to trial or you do this or that you're going to be harmed in any way, and no one's trying to provide you with goods or services to convince you to waive trial and enter a plea, or no one's forcing you to do this?
No, ma'am.
Okay. All right. Have you looked over the waiver of counsel? Have you executed it?
I just need to know where to sign. So to grant this one?
I don't remember if there's a line for me to sign in witness or that just gets filed in the court file, but either way is good. I just can't, I know extraditions I have to sign, but I don't know if there's a signature line there or not.
There is a signature for the judge of the district court on the day of whatever, and on this day of this year and all this stuff. For
Okay,
you.
well, they'll
But I
forward
did sign
it to
it.
me then.
I did sign it though.
Okay, so on count 1, 2, and 3, driving while suspended on or about the 16th day of February 23 in Butler County, Kansas, having an expired tag and no current proof of insurance. How do you plead?
Guilty, ma'am.
Okay. Were you operating a vehicle?
Yes, ma'am, it was.
And did you discover that your license was still suspended?
I discovered that during the traffic stop. Yes, ma'am.
Okay. And you didn't have proper registration or proof of insurance?
No, ma'am, and that was my fault. It wasn't my vehicle, but it was my fault because I did not make sure that it was up to code before I left in it.
Okay. All right, I'm gonna find you guilty of count 1, 2, and 3. Any specific recommendations, Mr. Regier, that aren't standard?
Your Honor, on the issue of waiver of counsel, if the court is finding that the defendant has successfully executed a written waiver, do I have leave to journalize that in the journal entry from today's hearing?
Yes, please.
Thank you, Your Honor. On counts 1, 2, and 3, the state is prepared to recommend a $100 fine for count 1, a $50 fine for count 2, and a $300 fine for count 3. Court costs of $108. I do not know if the court is making any findings that attorney's fees would apply in this matter under these circumstances, although my notes do appear to reflect that the court had previously appointed Mr. Patterson to this case. Insofar as underlying sentences are concerned, for counts 1 and 3, as those are charged as Class B misdemeanors, as the state understands, the state is recommending 120 days. For count 2, the unclassified misdemeanor, 30 days. The state does not object to concurrent sentencing in this matter. However, the state is respectfully suggesting that under these circumstances, a non-reporting probation for a period of 12 months is appropriate. I will, of course, defer to the court on the issue of repayment of the case.
Thank you.
Okay. Anything you want to say about your sentence or the recommendations?
Just that I am grateful. I do understand the sentence.
Okay. So on count 1, I'm sentencing you to 6 months in the county jail and $100 fine. I will place you on probation for 12 months to pay your fine and costs and order, of course, standard conditions, and that you not drive without a valid license. Count 2, a $50 fine and 5 days, but I will run that concurrent. So your controlling sentence is still 6 months in the county jail. And count 3, 6 months and the $300 fine and court cost. I will place you on probation for 1 year to pay that off. It's going to be a reporting probation because I want someone to help you make sure that you get your restricted license, that you get your license back, and that if you have a vehicle, it's properly insured. Now, long time ago, I heard this. I don't know if this is the case or not, but it used to be you could get public liability insurance for yourself. So even if you drove somebody's car, it would cover whatever car you were in. Okay.
Yeah.
So that if they didn't have insurance, you had insurance that would cover you. Either way, it's always best to have your own vehicle that you have registered, that you have insured, that you're on top of, and that you would get notice of any suspensions. That's why you have to keep your current address always current with the Department of Motor Vehicles too, because if they take administrative action against you, they have to send you something in writing in the mail, but only to the last address that you have listed with them. So if you never change your address, they don't have any duty to do anything more than just send it to that address.
Okay, that makes sense.
All right. So I'm going to release you today, but I want you to go check in with court services to start a probation with them.
Oh, yeah.
If you get a license, if you have insurance, and a vehicle with a tag, and you are low on money, they can come back to me and ask that your $300 fine on the no insurance be suspended, because I'd rather see you spend $300 to get 6 months worth of insurance or whatever, then, or 3 months worth of insurance, then you spend $300 on a fine.
Thank you.
But you have to have everything else done, and you have to have current proof of everything, and I can go back and waive the fine, but for now, I'm gonna impose it. And I'm not gonna impose any additional attorney's fees or costs. There probably is a minimal supervision fee that has to be assessed, because that's by court rule. But other than that, you have 12 months to make payments. Now, the other thing, again, this is all online now. When you've been convicted of a driving while suspended, often they resuspend your license for 30 to 90 days. So that's why you've got a year to clean this up. I don't know for sure how that's going to work for you, but you need to be cognizant of the fact that this conviction could prompt another suspension, or at least take that in consideration when you're petitioning for a restricted license. Okay?
Yes,
Do you have
ma'am.
any questions?
No, I appreciate all of you. Thank you so much.
All right, we are adjourned.
Your Honor, one final question. If the court is ordering the $6 probation fee and concurrent sentencing for all 3 counts, is the court making any orders concerning the time period for the case to be repaid?
For what?
Is the court saying a specific date for the case to be repaid in full, or is that what the 12 months is for?
I want her to do it within the 12 months, or they'll turn it over to collections, or they'll extend her probation, or they'll ask if they think that she has the ability to pay and she's refusing to, they'll file a warrant.
Very good, Your Honor.
But yeah, I'm gonna give her 12 months because I don't know what all she's gonna have to pay to get in a position to reinstate her license, to get insurance, to buy a vehicle, to
I still have current.
Once again, the title of the case is Frank and Karen Roberts versus Shelby and Chester Parr. Couple of observations. I said this, and I think everybody agreed. It was good eventually that this tenancy came to a close. They had been friends with each other, they'd been cordial with each other, but at this point, for a combination of reasons, it's for the best that they left, and there's new tenants, and I expect maybe in the future we'll have this sort of issue again, but I hope not. Secondly, we are in general civil court, not small claims court. Although this was conducted much like a small claims hearing, the rules of evidence apply. And the burden of proof in a civil case is the preponderance of evidence, and the burden is on the plaintiff. In the counterclaim, the burden for their counterclaim is on the defendant. Each party claims some things that they probably weren't entitled to, which goes to some of their credibility. But I tried to come out with as fair and equitable resolution here as I could. As I indicated, there were certainly problems from the landlord side, and the wheels all fell off in the spring on the tenant side. And this property was left in bad shape. And as I also indicated, this property could not be rented in a city or village that has code enforcement. The covenant of habitability speaks to some of that. This wasn't to the extent that the property wasn't habitable, although there is a fundamental habitability requirement for clean water. And this water is I wouldn't drink it. And apparently they didn't. So let's start with the first issue of rent. I was never able, either at the first hearing or this hearing, to get a completely clear answer from Mrs. Roberts on how they calculated the rent fee, the rent damages. And they're the plaintiff, so they have a burden of proving that beyond the preponderance of evidence. And anytime anyone comes in here in our landlord tenant case, I'm gonna ask, how much do they owe and why? So I went with Ms. Parr's figure because I found the plaintiff did not prove beyond a preponderance what the amount of rent due was. So I charged $1,750 for rent. And the supplemental complaint for money damages was hard to discern, frankly, because things were just lumped in together. And I'll say it again, Mr. and Mrs. Roberts, you could benefit from having an attorney help you from beginning to end to get a proper lease, which I doubt that you still have, and to help you with this sort of thing. But everything's lumped together. We got Roberts Brothers Excavating and all this front end loader and quad track and topsoil and high labor rates. And I just frankly cut it in half. 2,166.41 I awarded to the plaintiff on behalf of that. Jonathan Hagan's quote. I know Jonathan Hagan. He's married to their granddaughter. I know her too. All the stuff that's on Jonathan Hagan's quote needed to be done anyway, and in fact, still needs to be done. And the new tenants have moved in and none of this work has been done. I awarded 0 for that. Clearview Glass. The glass clearly was broken. I ordered $325 for glass. Even though the little pings from a pellet gun in the steel building look pretty minor, the estimate isn't out of the ordinary. $312 I allowed for the steel for that. The carpet definitely needed to be cleaned. In fact, that carpet needs to be replaced. I would guess it's probably 40 years old, possibly older. But I did allow $42.39 for the carpet cleaner. Photographs from Walgreens, I allowed $41.36. Jacqueline Hagan's cleaning bill, it was between $450 and $750. I allowed $550. Lawn care was $440. I cut it in half to $220. Light bulbs, $55. So the total damages for the plaintiffs is $4,406.95. 4406.95, which is certainly less than the $10,000 they were asking for. But frankly, I couldn't sort things out well enough, and I took the very expensive carpentry and repair because it needs to be done anyway. Now we subtract the security deposit of $1,200, which everybody agrees had been paid. There was an initial $900 and then a $1,200 security deposit, which still remain. So that leaves $3,206.95 owed to the Robertses. The defendant made a counterclaim. And again, she threw in a bunch of extra stuff just because. So I tried to take a look at that. I did order $200 for the violation of the lockout statute. She asked for $1,800 for 2 cases of water for 5 years. This water was certainly before any purification system was installed, not drinkable, and after, it was still not very good. I allowed $1,200. At some point, the plaintiffs put in some sort of purification system. I saw it. It's in that basement, but the water was still very, very hard. $1,200 for water for the term of their tenancy. I did allow your medical expenses. I saw the B places that needed more than a can of bug spray and wasp spray. I bet that might still be in there. And this young girl was 2 trips to the emergency room because of that. So I allowed that. Plaintiff contended their dog run was ripped down. I saw it. That's not $150, but he was taken down. I allowed $25 for it. And that's it. So the counterclaim requested $7,071. I allowed $2,075. So if I take what I awarded to the plaintiffs, 4,406 minus the security deposit is $3,206. So if I subtract what I allowed from the counterclaim, $2,075, it leaves total damages for the plaintiff in the amount of $1,131.95. If I add in the court costs of $229.22, which includes all of the filing and service fees and everything that went with it, I get a total of $1,361.17 for the plaintiff. Each side's claim was diminished. There was a large security deposit, fortunately, which was applied to the amount owed. I actually found they owed $4,400. To offset by much less than they were requesting, which leaves us with $1,131.95. I'm doing a money judgment at this time. You have 21 days to appeal this. 21 days from today would be, see, 20 days would be the 3rd of October, October 4th. And you have 21 days to pay this so they can pursue other collection remedies. My fear is that you executed the same sort of lease with your new tenant as you did with these tenants. I know you had a couple other rental properties. You could really benefit from getting a proper lease, having a lawyer help you with this stuff. In fact, I think in this circumstance, a lawyer probably would have paid for itself by helping with this. Anyway, that is my ruling. I haven't seen a bailiff all afternoon, but I'm going to take this property out and have the clerk execute it. So, Mr. and Mrs. Roberts, I'm going to ask you to go out to the counter, and I'll ask you guys to stay in here. And then you can each get a copy of this order. All right, we'll be in recess.
Sorry, he ended a bit quicker than anticipated, and I'm busy painting. I was trying to find this clip. I was trying to get this clip from my live last week without showing like things that I there was a Vaughn ear. Things that I don't want to show. I'm going to just quickly see.
And he throws that thing,
I think that's
not making money.
Oh, dancers for my.
pew-pewing.
I'm just trying to find the spot.
Well, you get used to it. Oh, that's another question I would like to ask.
Initially,
Fangled technology.
you know,
Sorry.
Years ago, so unacknowledged.
Oh, I always skip.
hey, look,
Yeah.
I got to run. One more question.
Thank you so much. One more question.
Go get my kid from school.
I have a quick one while she's looking. How tall are you? Sometimes somebody
Yes.
says 6'3", somebody, it kind of goes back and forth.
6'5".
Okay.
Yeah.
What is that in the rest of the world?
5'6" to 5'7".
5'6" to 5'7".
176, 78.
Sorry, I didn't mean to interrupt you, Vicky.
But weight?
My last question.
No, height.
178.
Centimeters. They're still in the imperial
what's
system.
wrong with you?
We're in the freedom units. They're still.
We didn't have to invent freedom units because we want to claim we are independent, so we'll make up. That's the same. How far is that away from you? Roughly banana pie. That's what I normally say when people ask it, because kilometers. What? That's communist, I believe.
You know, I will say that thank you for hanging out with us in court. We appreciate that you watch. I hope you enjoy it and learn from it, because that's what it is for everybody. It's an experience to learn, see what we do every day, and the idea is to also show it to kids so that they see what happens, so that they don't make the same mistakes.
I do have
and
one
those are
request. This
scary
is something we
guys.
used to do in radio all the time for longevity. Can you say, when I'm not in court, I watch Vicky Mac, please?
When I'm not in court, I'm with Vicky Mac. Or I watch
Brilliant.
Vicky.
It doesn't matter either way.
I love me some Vicky Mac. I do. I love your channel.
Brilliant.
Great. I do. And I watch you too.
Thank you.
Yeah, really. So thank you for having me. It's been real.
Thank you. I'm glad we finally got the time zones lined up and all of
And
that.
now I have to get back to real life. Daddy duty calls. 4 kids. Here we go.
Yeah.
So you're 3
we're
on
gonna
that line
watch
6
the-
years ago. So.
We're gonna watch the Mexican naked dance. I probably shouldn't have said the naked word before that, but
The driveway dancers.
Have fun. Yeah. And it was a great day today. It was a great day. So
It was fun.
yeah. Okay, guys. Well, I'll see you Monday, huh?
Yes.
yeah. See
Have
you.
me